All right. So, good evening, good morning, good afternoon, depending on where you are joining us from. And welcome to today's live session on the labor laws of Ghana. And it's proudly brought to you by the HR Certification Center. My name is Silas Apia, and I'll be your moderator for this very important discussion. So tonight we are focusing on a subject that affects every employee and employer. We are talking about the termination and enforcement of employment contracts. So today's topic is often discussed in organizations, is discussed among colleagues, and it raises a lot of misunderstandings. But that is the goal of today's discussion. We are here to provide you clarity, answer your questions, and then share practical insights with you. So, without taking too much time, I'll do a quick introduction of our facilitators and we'll zoom right into today's session. But before I do that, I'd like to know who we have on the call today. So, if you are joining in, you can put in the chat section where you are joining us from. So, you can say Silas from Spintex, you can say Ajwa from Kaswa. Let us know where you are connecting from so that we can acknowledge you. Okay, so I can see Clara. Clara, you're welcome. I can see Ahmed. I can see Mabel. I see Perpetual. I see Ebenezer. It's good to have you all. I can see Jennifer. Welcome, welcome, welcome. So, today we have put together a group of experts just to share and then debunk some of the myths, some of the misunderstandings that is surrounding termination of employment. So, to introduce our first speaker, Dr. Jeff Bassey is the founder of the HR Certification Center and the Institute of Leadership and Strategy. He has consulted and trained for over 200 organizations, including the Bank of Ghana, MTN, Newmont Ghana, Ghana Revenue Authority, Ghana Stock Exchange, Kenpisky Hotel, Coca-Cola, and Talo Oil. Dr. Bassi, you are welcome to today's session.
Yeah, thank you so much, and a very good evening to our August listeners.
Okay, thank you very much. It's good to have you on the call, sir. Now, to introduce our second facilitator or our second speaker, Wing Commander Sam Alute, retired, is an adjunct lecturer in the public sector management at GIMPA, a legal counsel with Integri solicitors and advocates, and the lead consultant for Alute and Associates Limited. Sam served in the Ghana Air Force for 18 years as an avionics engineer. His passion for human capital development, professional and personal development, and mentoring informs his vast network with corporate bodies. Sam has served on many boards and assisted organizations with strategy formulation, organizational development, and cultural transformation. He served in HR as the HR director with Africa Online Holdings in Kenya, Stanbic Ghana Limited, and Ghana Grid Company. Wing Commander Alute, it's good to have you on the call.
Yeah, thank you very much, Silas.
You're welcome, sir. And to introduce our last facilitator, Kofi Oti Edinkra is an attorney with an eye for detail and mind for critical thinking. He believes in and wills always to apply skills to multiple areas, especially in strategic analysis, legal compliance and validation, and dispute resolution. Until March 2019, he served as managing associate at the firm Atuguba and Associates, a member of the Ladder Group. In 2013, Kofi took part in a significant workshop on the development of the concept paper on affirmative action for persons with disabilities in Ghana. This initiative highlights his commitment to social justice, inclusivity with the legal framework, and addressing the unique challenges faced by persons. So, with his workshop and facilitations, he further attests to dedication to enhance capacity and contributions to the development frameworks and promote justice, equity, and inclusivity in Ghana. He's a strong believer and he holds both LLB and LLM degrees in law, as well as both the certificates of entry into the role of lawyers and the BL qualification, qualifying as a certificate to practice law. So, Lawyer Kofi Edinkra, you are welcome to today's session.
Thank you very much, Silas. If I hadn't heard my name, I wouldn't have known it was me you were talking about.
A very heavy profile from all our experts, and I'd like to say we are very happy to have you on the call today. Thank you very much for joining in. So, before we zoom into the questions we have and try to explain some of the misunderstandings that are in our workplaces today, I'd like to take the opening remark from all our facilitators. So I'll start with you, Kofi. So today we are talking about termination. We are talking about termination and enforcement of employment contracts under the Ghana's Labor Act 651. So Kofi, what is your take on this particular topic, especially about termination in our workplaces today?
Okay, thank you very much. I think that this topic is very relevant, as I told you when you initially informed me about it,
Mm,
because a lot, I mean, we have to face it that many good things will come to an end, many bad things will come to an end. Sometimes we need to transition into other roles or for career advancement or for whatever other purposes. But
mm,
a lot of the time, when we do not know how to transition properly, then we are either undervalued, and then we leave with less than we should have, or because the transition process may not be managed properly, then it leads to a strain in relationships. But hopefully by the end of this session, we would all know how to manage our transition processes well, so that we can both achieve mutually beneficial results. Thank you.
thank you very much, Kofi. Thank you. We are grateful. So, Wing Commander Luti.
Yes, thank you, Silas. I share the views expressed. Terminations normally come with a lot of pain and some sadness,
Mm,
because some feel aggrieved because they believe that due process has not been followed. But there are ample provisions in the Labor Act as to when and why the employment relationship can be terminated. And I'm hoping that this webinar will shed some light on that, so that we can avoid the rush to the commission or to the courts in instances of unfair termination. Thank you.
very well. Thank you very much, Wing Commander Luti. And from our last facilitator, Dr. Bassi, I'd like to take your opening remark.
All right. Thank you for the opportunity, and a very good evening once again to our August participants. This is a session I have participated in several times, and for those who are probably in here listening to me once again, I always say that HR is a heavily legally regulated profession, and you can't do things at your whims. Terminations are governed by law, and I'm hoping that together with myself, my co panelists can do justice to the issues. Sometimes all the HR wants to tell himself is, yeah, there's evidence that the employee have committed offense. Well, beyond the substance of the offense, there are also procedural issues, which, when compromised, can drive the organization into avoidable liabilities. And so I'm hoping that we can share some working knowledge behind the law, not just the letter of the law, but also the spirit of the law to aid our August participants to, as it were, step up their game when it comes to managing some of these processes. By far, unfair terminations are probably the most contentious area, especially when you get to the labor courts and the National Labor Commission. And so I'm looking forward to we having a good engagement this evening to do justice to the issues.
All right. Thank you very much, Dr. Bassing. Very, very great intro. And I'd like us to zoom right into the questions. I'd like to let our August participants and our audience know that you can put your questions in the chat box, and when it's time for the Q&A, I'll do well to read each and everyone's question so that our facilitators or experts will be able to attend to them. Okay, so Kofi, I'll direct the first question to you. So,
Sure.
what legally justifies termination of an employment contract?
Okay. That's a simple and complicated question at the same time. So it's a
Mm,
simple because what legally justifies termination is what the law says allows you to terminate. However, the complication is that there are many aspects of, I mean, human endeavor is very complex. And so there are several situations that either fall into gray areas or that might seem one way, but when you go into it, then they turn out into another. And this is because, as I like to say, the law is in the book, but it also has to be practicalized. And sometimes what you think may be the situation may be different from what you can show, and so it leads to some complications. But in simple terms, what allows for termination is quite a number. So either an employee is sick for a long time and can no longer work, or an employee is incompetent, is unavailable, an employee dies, which is a very simple one, or an employee wants to move on, or for an employer's part, an employer is undergoing a change. Either they are changing the way they operate, moving from manual labor to computerized labor, or the employer has been bought by another company. And so some changes have to come in. I mean, just in a nutshell, these are some of the things that allow for either termination or a radical change in the nature of the employment relationship. That's what I would say for now.
okay, thank you, Kofi. So, during your submission, you mentioned some scenarios that will justify termination. Um, I want to direct this question to Wing Commander Alute. Does resignation require the same notice period as dismissal? Because there are many instances in our workplaces where either the employer gets up and says that I've had enough, so go home. So your contract has been terminated. And there are instances where the employee can just come and then say that I am done with you and I want to move on to another job. My question is, does resignation require the same notice period as dismissal?
Thank you for the question. The notice period required based on your tenure, whether you've been there for 3 years or less than 3 years, or the nature of your contract, is provided for in Section 17 of Act 651, that's the Labor Act. But when it comes to dismissal, it can be with or without notice. Uh, it is unlikely that you dismiss somebody and you still want the person to hang around. So the purposive interpretation says that for dismissal, once the fact has been determined by disciplinary committee that is liable and the sanction for the offense is dismissal, you don't have to give any notice. you issue the award, and the person will have to take whatever is due him, and he has to go.
Okay, so um, per the submission you made, you said dismissal does not necessarily need any notice. So is it for every job, or there are certain categories of workers that can be dismissed, but there's a need for a notice? Still on you, Wing Commander Lutin.
Yes, like I mentioned, you see, the act is made for all jobs covered under the act. Of course, it excludes the security services, and so if it's either private sector or public sector, once an employment relationship is established per the contract, then the Labor Act kicks in. Now, the Labor Act gives instances where the termination can be even at the close of day. So the notice period for dismissal, it's not a requirement. That yes, you have gone through the whole disciplinary process and you have been found liable, and your contract says we should give you, if you want to leave us, you give us 3 months notice. So we are giving you 3 months notice to leave the organization. When we are dismissing you, then definitely there's something wrong with the law, because the dismissal means that the employment relationship has broken beyond reconciliation. We cannot, continue with the relationship again, and we issue you the letter and we pay you what we have to pay you, and that's it. I don't know what Kofi has in that regard. Thank you.
Okay, thank you. Kofi, will you like to add to what Wing Commander just said?
Yes, but please, can you clarify the question for me again?
So we are talking about the notice period for dismissal. So my question is it for every job, or there are specific jobs that even in the instance of dismissal, there's supposed to be a form of notice?
You're supposed to hear a form of pardon.
Notice.
Okay, okay. No, no, no. I agree with what Wing Commander said. It's not every. Um, I mean, first of all, for every job, once there's an employment relationship, then it's regulated by Act 651, and Act 651 provides for termination. Let me just put that baseline. However, ordinarily, you are entitled to notice, but this question you are asking is about notice termination that is coming out of disciplinary procedures or disciplinary scenarios. And for that, depending on what may have occurred, you may not be entitled to notice at all. And so you can be dismissed outright, especially usually for grievous offenses and offenses where, how do I put this? The lawyers will say for an offense where you are caught in flagrant delicto, that is, so an offense that occurs, how when commander, how should I put this? um an offense, I mean, you are caught in the act, or it's something, it's so glaring, we do not need evidence, we do not need further evidence. The thing occurs in front of us. There may be security cameras, or it may have occurred before a gathering of all employees or something like that. For that, as when commander says, if we still have to do the same thing, if we have to do the same thing all the time, then there is something wrong with the law. So yes, ordinarily, notice is required. Notice is important. However, ordinarily, the use of ordinarily should also tell you that there are situations where such notice need not be given. You can be dismissed without notice. So that's what I'd say.
Yeah.
All right. Thank you for adding your voice to that. Thank you so much. And this question goes to Dr. Bassel. So, Doc, in instances where there's something we call lieu of notice. That's payment in lieu of notice. Is it always lawful? And I think for our listeners who might not have a fair understanding of what payment of lieu payment in lieu of notice is, we would just like to clarify that term and then answer the question: is it always lawful for an employee or an employer to make payment in lieu of notice?
Very well. Thank you. So the let me first add my voice to my senior colleagues that there are different forms of separation, as it were. This dismissal, for instance, as you were talking about earlier on, it's a form of termination, which it's quite beyond the ordinary separation, and for which reason issues of payment in lieu of notice probably doesn't come in. But there are offenses that require termination either initiated by the employer or resignation, as is always initiated by the employee. And then the law makes provision for pay me if you cannot afford to give me that notice, as required. And once that is the case and as recognized by the law, it is applicable to, let me say, other forms of termination other than dismissal. So it can be terminations due to offenses as spelled out in Section 15 of the Labor Act, um, or matters of resignation. Now, the in many organizations, I mean Newmont and a few other organizations, the moment we know that you are leaving or we are separating you, we are no longer comfortable with you in our system. So we may not even pay you in lieu of notice, but we grant you some sort of a garden leave till your time is due. And the reasons would be that you are no longer trusted in our system. But then again, as and when we need you to deliver a piece of information or release something to us, we can still call on you. So, yes, in lieu of notice is the case for nearly all forms of separations or terminations, except the type called dismissal. And it is both parties, it's either way. And normally it's aligned to the period so agreed. Section 17 is what tries to regulate notice requirements. And as Commander Alote had already mentioned, if the relationship is 3 years or more, you are required to provide us with a month's notice. Otherwise, you pay in lieu of notice. Otherwise, if we are the one separating you, terminating the appointment, we also give you a month notice. Now, but you see, Section 19 seemed to suggest that quite beyond the 1 month or if less than 3 years, 2 week notice, as indicated in Section 17, you actually um, can have some agreement, which is encouraged by Section 19 of the Labor Act, depending on the nature of the work and how sensitive the role is. For instance, a school teacher, I mean, you are preparing those young ones in junior high for BC. You may not just leave in the middle of the term, which may affect the psyche of the children. So we said you can give us 3 month notice, which is more like a term for the school to take time to get you a befitting replacement before you leave. So technically, we can say that Section 19 sort of make nonsense of Section 17, if I'm allowed to say that. The only time we probably want to apply Section 17 to the letter is when you fail to take advantage of the agreement between two of you, so preferred by Section 19. Now, whether it's a 1 month notice required, 2 weeks, as in the case of those who are less than 3 years, or any other agreed as encouraged by Section 19, be it 2 months or 3 months, the payment in lieu of notice have to align with the period required. Otherwise, then it doesn't serve, the purpose. So yes, that's what I have to say. That in lieu of notice, in many cases, as the law permits, can be done, but should not be abused. It must always be aligned to the notice required, and it can be either way. I'll be happy if my senior colleagues will want to add a thing or two to my position.
All right. Thank you, Dr. Basi. So, Wing Commander, would you like to add your
Yes,
voice?
yes. So as Dr. Bassi mentioned, Section 19 is just trying to indicate that the 17 requirements are minimum requirements. So
Mm,
if there's a collective agreement and there are more favorable terms in it, for instance, it says that, okay, you can give 1 month notice or you can give 3 months notice if it's the employer who is letting you go, then those will be respected.
okay.
But otherwise, we stick to the rule book, which is the 17. It's 1 month, 2 weeks, or determined at will. If it's a contract that says that you can be terminated, especially casual labor coming to do some work for that day, we don't have to give any such notice period. The other thing about the notice period is that it talks to a fundamental rule, which is the employment at will, that you are joining the organization on your own volition. And if for some reason you have to leave, and that's going to inconvenience the employer, then you have to at least compensate in a way by paying in lieu of that notice. Maybe you've gotten a better job, you are leaving them suddenly, and they will have to make some adjustments. So it's the reason for that. But most times the employer is not too how do I say it, chasing you for a leave of notice. It's depending on how the separation is done, but it is a clause that is normally in the contract. So once you are trying to savor the relationship, you have to just look at what you signed up to and live by your promises. Thank you.
A follow-up, Wing Commander, and any of our experts can touch on it. You see, there are instances where people work without a written contract. In such instances, if the person wants to either exit with a lieu of notice or they want to be able to separate from the company, how do you go about such a situation?
That is the section 17, the notice of termination of employment. So where you don't have a contract, then we default to the law. The act is superior to any policies that might emanate from it in terms of
Mhm.
your own employment HR manual. So in the absence of expressly stated, then we go to the act for the minimum requirements.
Okay. Okay. All right.
But
Uh,
Kofi can shed some light.
okay.
Yes, yeah. So, if I was going to say a similar thing, that there's a difference between having an employment relationship and having that relationship reduced into writing. Once you have an agreement, it is the existing contract of employment that is reduced into writing. So you have the contract first, then you reduce it into writing. And in addition to that, what Commander said, the act is the default conditions of service for everyone. And so what you reduce into writing should either be equal in terms of duties and in terms of its benefits, or better than what's in the act itself. And so if you don't have written conditions of employment, it doesn't mean that you don't have conditions of employment. And so you will just follow what is what is the default, which is what is in the law.
Mm.
However, the let me just add this, that it is okay not to have your written conditions of employment on the first day. It's not the best, it's not ideal, but it's not fatal. However, as soon as possible and not beyond having been in the employment for 2 months, you should have that written contract. I know there are many people like that who start working without having their contracts. However, despite all that I have said, if it comes to termination, the act will apply. It's as simple as that. That's what I'd say. Thank you.
Okay. Um, Kofi, still on you.
Yes.
There, I have heard about stories where an employer walks into the office, and because of probably something the employee has done, the employer uses their authority as either the employer or the owner of the business, and then sacks. I'm using a common word, sacks the employee. Um, there are these instances unfair termination, and to some extent, what exactly can be considered as an unfair termination under the Act 651?
Okay. All right. Thank you. This is a very good question. So first, let's start with the being sacked at will. And let me provide a clarification. I know a lot of us, we watch a lot of series, movies, which are mostly influenced by the Hollywood or United States law or arrangement. Now, the thing is that over there, they have what is actually at will employment, where we say you are fired and you are indeed fired. You have to pack your things and go that day. We do not have that here. Even here, even where you are allowed to be dismissed as close as possible to what is on the spot, it means it's actually your employment coming to an end on the day, so it takes effect the following day. But let's put that aside. Um the the thing about whether you have been unfairly terminated or not. And actually, another clarification here is that there's a difference between wrongful termination and then unfair termination. Now, wrongful termination has to do with it has to do with the procedure for severance of the relationship. And then unfair termination has to do with the reason. So, unfair termination, maybe you are being sacked because you are pregnant. That would be unfair termination. And wrongful termination is where you are being sacked for a legitimate reason, but the wrong procedure was used, such as where your boss comes in and finds that you have committed an offense. But that offense is one that requires you receiving a query or proper investigation to be done to prove the misconduct. So where the misconduct has to be proven, but it is not, and they just fire you because we think that that is what you did, then we are talking about wrongful termination, and that can lead to a lot of issues. So I would say yes, it depends on what has happened. If it is one of those scenarios that I tried explaining earlier, where you are caught in the act, where you have committed an offense that is so egregious, it's so terrible, and it's so glaring, it's so clear that we do not need to go through the whole procedure of setting a committee, ask you to appear, we investigate, blah blah blah, all of that. You may be dismissed, but even that, you are not going home there and then. It means it's still at the end of a period, just that it's a very short period. um, and also to add on to that, I think I've already said that, where you are being fired for a reason that is unfair, then we are talking about unfair termination versus wrongful termination. But you can actually terminate in a relationship in a way that is both wrongful and unfair. So in that case, you've used the wrong procedure, and the reason is also unfair. You can be terminated for a solid reason, but it is still wrongful. So that is what I would say. Thank you.
Thank you, lawyer Kofi. Dr. Bassi, would you want to add something to that?
No, I'm quite satisfied with the answers coming from my senior colleagues.
All right. Okay. So thanks for that, Lawyer Kofi. And this question goes to Wing Commander Alute. So, Wing Commander, what are the remedies that are available to an employee who is unfairly terminated? Hello, Wing Commander, you are muted.
Oh,
So,
yes, my apologies. Yeah, so the remedies, I mean, if it is really established that
mm,
there's been a procedural breach or a breach of the law, the act itself, and you apply to you complain to the National Labor Commission, then they can ask the employer to reinstate you or to re-employ you in a similar role if the role you held before has been taken up, or to pay you some compensation by way of damages. So these are the three broad categories. If really, as Kofi said, it's as a procedural breach, or that one is very technical, because what happens is that your policy says in the event of an infraction, this is what I'm going to do, but you didn't do it. It means there's some malice aforethought. And
okay.
these are the three remedies that you may request, ask for.
Um, Wing Commander, can you take the three remedies again? We had the last two.
Yes, the first one is to reinstate you. If when
Okay.
they found that the termination was unfair, so they'll ask them to take you back. Or they say that, oh, but well, for the period he was fighting this at the commission, his job was critical. So somebody has taken up that job. We can't ask the person to lead it. Okay, then find some other similar role that matches his job specifications, his skill sets, and seniority and all that. And if the employer says, I still can't find anything, then they'll have to pay the compensation to the worker.
Okay. Okay.
And sometimes they would consider the time the worker has been inconvenienced, been out of a job because of that wrongful termination. And some awards can be very interesting. Thank you.
Okay. So Wing Commander, you made mention of going to the Commission. I'll direct this question to Dr. Bassi. What are the steps if an employee wants to have a solution or a remedy to being unfairly terminated? What exactly are the procedures and how far can they go with their quest for remedy?
Yeah, thank you. This question should be going to the qualified lawyers. I don't know why you're asking for steps that I'll share my thoughts with you. In fact, my experience with you, especially with the National Labor Commission.
All right.
Um, oh, ordinarily, you would first file a complaint. You would get to the commission, pick a complaint form, and then you file your complaint. The National Labor Commission will normally, look at whether there's, a reasonable cause. There are a few things they look at: the time period, the capacity of the person filing the complaint, etc. And then they will most likely send, will I call it a summons to the respondent. In most cases, that will be the employer. Not always, but most employers would be the last to rush to the National Labor Commission. It's mostly the complainants are mostly the worker, or maybe a class action, or even the union, etc. And so when that summons is served on the respondent for purposes of better description, normally the period to respond will be stated, and it's usually some 14 working days stated in the summons to the respondent. We expect that the employer will respond within the 14 days. But in the event that the employer doesn't do so, normally this is just a practice. It is not obligatory on the Labor Commission. They normally would probably give you a 7 day grace period to do so. But they can waive that and still want to listen to the case, maybe in absentia. But chances are most employers would have responded within the 14 days or the 7 day period, except for the high profile cases, the Ghana Medical Association versus government, where lives are being lost, etc. Most of the regular employer-employee cases of wrongful or unfair termination issues, you will normally meet what we call a facilitation committee, and the idea is to attempt do some sort of pre-trial, attempt conciliation. That meeting would normally last 2 or 3 sessions, and if there's a deadlock, if either parties are still entrenched with their positions and they are not ready to maybe give in as to there's a wrongdoing, I agree to pay X, Y, Z. The second stage is normally for the case to be escalated for maybe mediation, or some cases arbitration. The two are not exactly the same, but mostly it is mediation. And if it still doesn't work at that stage, because mediators really do not have the power to maybe enforce a judgment or their own determined decision on you. The two parties more or less have to agree that yes, I accept ABCD and I'm willing to pay or do this settlement or that. But the moment that agreement is reduced into writing, it is binding as though it was delivered by the 7 member commission. But even if that process fails, the issue can further be escalated to the 7 member committee to look at, to determine the case. And they are clothed with the powers of the High Court. And so when they make a determination, the expectation is that you would execute. But of course, they don't have enforcement powers. If they ask you to execute on ABCD and you fail to do so, they can go to the High Court for enforcement powers, as it were, to get you to do. But of course, we all know that we run the appellate system in Ghana, and since the Labour Commission is at the same level of the High Court, if I may say so, you may want to go to the Court of Appeals seeking maybe to overturn the decision, and it can go all the way to maybe the SC, etc. Now, the process on the whole, my experience have been between a year and 2 years, most of the time, though there are always exceptional cases. Particular case I represented the organization at the Labour Commission lasted 4 years. Some could also be much earlier than that. So these are the the processes at the Labour Commission. Just for I just try to summarize it. There are a few other nuances here and there, such as when the employer, for instance, fails to respond, the commission will either hear the case in absentia or maybe with the assistance of the High Court, subpoena you, etc. All of those options are there. But on the whole, these are the normal processes we see at the National Labour Commission if you are seeking a redress or some sort of settlement, as they are close to settle disputes between the employer and the employee. And but let me say that the entire process at the National Labour Commission is non-adversarial, other than the courtroom where it is I put it to you, I put it to you. It's more or less like once you enter the courtroom, the parties have become enemies. At the National Labour Commission, the processes are quite malleable, and the goal is to settle dispute and reconcile two parties where possible, more or less. So it is a bit non-adversarial as compared to the traditional court settings.
All right. Thank you, Dr. Bassi. And I think you've done justice to that question. So I'll ask my last question, then go to the comment section to see what our audience and participants have for us there. So this question is directed to Wing Commander Lute. Um, are probationary and fixed term contracts employees treated differently in terminations?
Yes, I think that is a very broad statement because the grounds for termination would apply provided the fact that you are on probation, for instance, doesn't mean that you can, get away with anything. The law, the policies and procedures apply to you. Is there some benefits that you may not be extended to you because of your probationary status? So whether you're on contract, you're on probation, if you misconduct yourself, then the disciplinary procedures will come to bear. But
Mm,
the grounds for termination at section 15a says by mutual termination, by mutual agreement. So within that period, if the employer realizes that maybe you are in breach, your medical didn't turn out well, your certificates, had issues with it. Like in the classic case, a very interesting case, National Labour Commission versus Ghana Telecom, in I think it's a 2019 case, which went all the way to the Supreme Court because somebody had some certificates had did some error, whether it's internal, but it was seen as a dishonest statement. It doesn't matter whether you are on probation or contract; those things would apply because the law will definitely bind you once you have an employment contract, irrespective of the nature of that contract. The policies are binding. I hope
mm.
I have addressed it. Or there's
Very
something
well.
else you wanted to ask.
Very well. You have because um, there's this. Let me use misunderstanding because I understand it better now. But there's this misunderstanding that if you are a probationary worker, or probably you are working as a fixed term contract employee, then there are some leeway or some instances you can get away with some of the misconducts. So I'm glad you touched on that and you made it clear. All right, thank you. So
You're welcome.
I'd like to go to the comment section and read the questions from our audience. But before I do that, I would like us to know that this session is proudly brought to you by the HR Certification Center, an institute that is committed and dedicated to people training and HR capacity building. And I'd like us to take a quick word from our sponsors. When we come back, we will listen to the questions that our audience have. We'll be right back.
As HR leaders and functional line managers, decisions that we make daily can have legal implications. From recruitment to onboarding, discipline to termination, every step must be in alignment with the law. With this, we have put together legal training for HRs and line managers. This course is designed to give you the knowledge and clarity to lead lawfully. We will break down Ghana's Labor Act 651 in a simple, practical way. You will learn what the law actually says and what that means for your work. Do you know the probationary periods? Or how to properly document issues to prevent future legal risks? These are the things that are really important as a leader and to safeguard your organization. Whether you're a seasoned manager or a new business executive, This course is simply designed for you. To join our next cohort, call or WhatsApp 020-800-7585. It's your time to hop on the legal train.
Okay, so welcome back. And that's ad was on the legal training for HR and line managers that is coming up on October 25 to November 29. So if you are either an HR manager, a line manager, or anyone in a position where you manage people, just call on us 020-800-7585 and just make enquiries, find out more about this program, and we will have our admissions officer attend to you. Now, lawyer Kofi Edinkra, this question goes to you. And Alberta writes, with reference to termination on health grounds, is it okay to proceed to medically off board in line with the company's policy, or one has to constitute a medical board with a rep from SNIT, the employee's doctor and the company's doctor, etc., before terminating an employee's appointment due to ill health? I think this is talking about ill health and situations of terminations based on health grounds.
Okay. I'm not sure I get the full question, but let me provide a response, and
All
let's
right.
see if it will sort it out. So the when it comes to termination on health grounds, the first thing that I'd say is that the the ground of ill health has to be something that is prolonged, because there's sick leave, remember, and with sick leave,
That's
usually
true.
they'll continue paying your pay. I mean, in practice, a lot of the time, 3 months you keep getting your salary. The next 3 months, half salary, and then at the end of that, if you are still not well, then the employer will decide what to do. But if they are going to terminate, then yes, a determination has to be made that you are no longer fit to continue in that employment, and it will definitely need the analysis of a doctor or a health professional. And so I mean, it depends on where you work and the policies that are there. The law does not provide a hard and fast rule on how to practicalize the determination that you are no longer fit for purpose on health grounds. In the sense, unlike workmen's compensation, where there's more structure to the determination. There's a board, there's a committee that determines. It's not like that over here. So largely, it depends on what is contained in the employer's code, the employer's manual, or the policies at the workplace, or in the absence of that, what is fair. Because remember that when it comes to termination, the Act 651, the Labor Act actually says that if the employer is not able to show that the reason or the grounds for termination are fair, then it is deemed to be unfair termination. So in that light, there's no hard and fast rule that they have to constitute, a committee that has a representative of SNET on it, or whatever that it is. It just has to be a fair determination that, looking at the situation, and of course, what is reasonable here would be, since the employer is likely not a health professional, or an institution of health professionals, to get the input from either recognized health professionals to come to a determination that you are no longer fit. Then, if the decision is taken to terminate, what is your entitlement is then calculated for you. And of course, that SNIT is automatic. I mean, until the point where you are terminated, you are in the employment, you are in the employ of your employer.
Yeah.
And
Yeah.
so your SNIT will continue being paid. And so that should not be a problem. What may be needed would be maybe if you have any deferred leave, if you have any deferred entitlement, annual bonuses that have not been paid yet, any sort of entitlement that is calculated, and then it is paid to you. And of course, depending on the workplace, they may have some other end of service benefits or some severance benefits that will be added. It's calculated, and then it is paid to you. So that would be my response.
Right. That was a very strong take. Thank you for that. So the next question, I'll direct it to Dr. Bassi. And for purpose of confidentiality, I wouldn't want to project the person with their name. So the question is, what do I do if I want to resign and give a month notice, but I can't give the month notice because my new offer date wouldn't allow me to? But I don't also have money to pay the company a month in lieu of notice. What other alternative do I have? That's a good question.
All right, I will give it a shot, and my senior colleague, Commander Alote, can add his voice. The law requires you to provide notice or pay in lieu of notice. If you don't do either of the two, I would say the only other option, which would be a question of discretion, will be for you to try and speak to your employer. But if he says no, there's very little you can do. You would have to do one of the two. Otherwise, you go ahead and break the law, as it were, and face the consequences. And let me say that, mostly because these issues are not big issues, the employer may not really pursue you. Is it within his right to pursue you for not
Yeah.
paying in lieu of notice and also not providing notice? Yes, it's his right. So he decides whether he's coming after you or not. And an employer can come after you through a lawyer. He doesn't need to be in court. You only send a lawyer after you, if for nothing, to tell others in the organization that don't treat the company this way in the near future. As much as it might not be a big deal to the employer, some employers, if I were the employer, I would do that. I will come after you just to tell your colleagues that you are leaving behind not to take the system for granted. So you would have to go by the two. Otherwise, go and plead or negotiate with your employer. How do you not end one employment relationship yet to take the other? And I'm sure in the mind of the framers of the law, these will be one of the reasons they will give you options as pay in lieu of notice, depending on exigencies, whether on the part of the employer or yourself in this case. And so you would possibly have to look for the money and pay in lieu of notice, even if you have to take a facility or a loan. Otherwise, like I said, really, there's no other option rather than maybe to go plead or negotiate with the employer or something. I don't have any further experience on this to share. If Commander Alote want to shed some light on it, I'll be grateful.
Okay, yeah, thanks, Dr. Bassi. Yeah, I think that normally one would expect that one should plan his or her exit. You can trade leave. It's good to not take all your leave so that you can say that, I'm supposed to give you notice of 1 month, but I have outstanding leave that you have to pay to me.
Mhm.
So net it off. Some organizations will say, okay, yes, we are going to pay you your entitlement. So we are going to net off this leave. But if you exhausted all your leave, then you are a debtor now because you have to find that money to pay. As Dr. Bassi said, most times people don't push. You can just, but if you have money with them, they'll definitely set it off. The other thing
Mm.
is you should ask your new employer to pick it up. If they really want you that badly, they pick it up.
Okay.
Some even pick up your bonus. You know that, okay, bonus will be paid in September. They want you in May. You are going to lose it. Or in some organizations, like one that I work for, they split the bonus beyond a certain figure into two. They pay part in March. And then they know that most times people want to use the September to exit. So that one, you forfeit it. So if you forfeit your September, then you go to your employer and say, you know what, I'll be financially disadvantaged. So if you could, take this up, I'll be most grateful. So I agree with Dr. Bassi. You have to negotiate it. But it's good if you have some leave to trade off. It helps you, puts you in a comfortable position. Thank you.
Mm, thank you. So, if I understand the submission from Dr. Bassi and Wing Commander, in summary, you can either send the you can save your notice period where you send the information ahead of time. You can do the payment in lieu of notice, and just as Wing Commander added, you can speak with your new employer so that he can step in and assist you with it. Aside from these ones, then there is really no other option. Okay, thank you very much. So I believe the one who asked the question has gotten an answer to it. Now, the next question is from Samuel Bonsu, and this will be directed to Kofi. So Kofi, someone is asking, what are the provisions in the law for employees whose contracts get terminated due to business closure? And I believe the business closure is the business has either collapsed or it has been closed after 6 years with the employer. However, the original contract between the two parties states 2 years renewable.
Okay.
Hmm.
So there's a missing detail as to whether at the time that the business was closing, it was up for renewal and had been renewed or not. But either way, this sounds like where the business is coming to an end, and so there is no employment to be had. Now the thing is, just as we spoke about redundancy earlier, where the enterprise, the occupation, the occupation or the institution is going through some changes. It can change and it can metamorphose into something else, or it can simply close down. Another institution can buy your employer and shut down that business, for whatever reason. Now, if that is the case, the best thing that can be done is to, the law requires at least 3 months ahead of that closure for the union and the chief labor officer to be informed. And
Okay.
that's step one. And then step two, negotiate with either the employee, or if the employee is represented by a union, you negotiate with the union on how to phase you out, and that would include your severance package. That is, and so that's the severance package, and practically, they may come up with a formula depending on the category of worker, and how many years you've worked. You get a certain number of months as part of your severance package. So if you work for every 2 years, we pay you 3 months of your salary or something like that. It's all mostly due to negotiation. If you can't negotiate, then you are going back to the chief labor officer or to the National Labor Commission to
Wow.
settle that dispute. But the fact that the contract should have been renewed, and perhaps I think the person is thinking of a situation where the employee may have arranged their life with a legitimate expectation that the employment would continue and it would be renewed. All of that
Yeah.
is factored into the negotiation for the severance package. But I will say that depending on why the business is closing, if it's closing because business is terrible and the employer is already in a difficult financial situation, more or less they are bankrupt, it can only go so far. When it reaches a certain level, no matter what you do, if we don't have, I'm collecting and I don't have, they will tell you that I don't have is always stronger. That's what they will
Hmm.
say. But it's largely based on negotiation. Yes, if it's coming to an end.
Lawyer, this one, a lot of people will say they don't have who at this point.
You see that and that is why, especially for workers that are represented by unions,
Hmm.
um, it is not as easy. It's not as simple as saying I don't have any, and then you go. Unions are very strong, and unions also have access to information that you may even be surprised. And so, if you say you don't have, it's something that you would have to prove.
Okay.
It's something that you would have to prove. And at the end of the day, if there's a dispute, you say you don't have, and we do not believe you, you are going to submit the dispute to the authorities, and the authorities can require each side to show what they have and what they do not have. And so it's not as
Yes.
simple as it's not as simple as that.
Okay. All right. Thank you for that. Um. So, Wing Commander, Joyce is asking, what is summary dismissal and what circumstances lead to its application?
Okay. Um, Summary dismissal must first of all be captured in the policy. You know, there is the progressive disciplinary approach. We have some uh, offenses that go to the very core of the relationship. One may be assault. You go and give your chief executive a good slap, and you expect that you continue to stay in that organization. You know, they will have a policy that prevents such unruly behavior. So they will classify that these types of offenses are summary dismissal offenses. Now, some believe that when they say summarily, it means that they will dismiss you on the spot. No, it will still
Yeah.
have to go through the disciplinary process, and you have to go because it is your right. You know, it is a constitutional right to a fair hearing. So we still want to know, yes, you've crossed the line, but we have to still know your reasons for crossing the line. And we would read the route act to you, you know, what punishments should apply. So when we say summary dismissal, it means that the offense is so grievous that the employment relationship cannot continue. And by once established, you have to leave the organization.
Okay. Thank you for that. Um, so because of time, I'll just go to the next one so that we'll be able to answer as many questions as possible. Dr. Bassi, this question is to you. The the Emmanuel is asking, does the collective agreement of an organization take precedence over the Labor Act? Pursuant to Section 19.
every every law. Now, there's hierarchy of laws, and in the space of labor, well, we can even take it from the Constitution, which is supposed to be the chief law, aside the ILO regulations that we have ratified through Parliament, the ILO regulations that we have ratified. Other than that, then is the constitution. Below the constitution are the municipal laws or the acts of parliament, and the key among those laws are the labor ones. We consider the Labor Act 651 2003, the offices, shops, and factories, and the workman's compensation law and all of that. But and then of course there are also allies and all of that. The whole issue of the collective agreement itself is taken care of by the law. In fact, everything unions and the collective agreement and all of that, you can just look at the section 79 through 105. And then 108 tries addressing when there is even a conflict between the contract of employment and the collective agreement. It's difficult to say an agreed or agreement between an employer and employee in the name of collective agreement would take precedence over a sacrosanct position taken in the Labor Act. That would be more like contracting the organization or contracting yourselves out of legislation. So largely, no, you cannot go agree on things that the law have taken absolute positions on. There are, however, gray areas in the law. The law allows the employer and the employee to have agreed positions on those ones. Those ones can be explored. But if we generically say that provisions in collective agreement may take precedence over what is stated in the Labor Act, we will make organizations ungovernable, more or less like contracting them out of legislation. So my answer generally is no, except certain provisions in the law that allow the employer and the employee to agree on how to handle a few things in the name of collective agreements. So yes, that is what I would say. The answer is no. However, you can explore those gray areas and areas that the law allows you to have positions on.
All right. So the next question to lawyer Dinkra. Now, Lily says, "Thanks for the insights. Please, can an employee be separated on statutory grounds if unable to reconcile their date of birth with SNIT and the company? For instance, the employee's date of birth with SNIT is different from what he provided to the company. His birth certificate, which is the new one, and the Ghana card reflects what he provided to the company, but not SNIT. Can the organization base on that of SNITs to separate statutorily?"
Okay, so this is a very good example of a situation where if you want to terminate the contract of employment, that if you're an employer that wants to terminate the contract of employment, you would
Mm,
need to go through an investigative procedure.
okay.
To my mind, what you can ask here, this could be a misconduct by perhaps alleging that the employee has made a false misstatement or has made a false statement or a false declaration to the employer with regard to their personal details, either to avoid retiring early or to meet certain criteria that were advertised for applicants to be of a certain age, something like that. And so over here, clearly, it requires an investigation. First, they'll query you to show reasons why disciplinary action should not be taken against you for lying to the company or something like that. And the allegations would be that, look, your records do not match. And so come and explain. When you are given the chance to explain, then you would need to explain. And depending on what you tell the employers committee, a decision may be taken one way or the other. However, practically, if you give, if depending on what you say, honestly, depending on what you say, if it's a situation of forged documents or something like that, you can find yourself out of the company. But if it is just some clerical errors or something like that, then I would say that this may not meet the threshold for you to be sacked, but then you may still maybe some a warning or something like that. I think it was Wing Commander, either Wing Commander or Dr. Bassey that mentioned graduated levels of punishment or levels of discipline.
Yes,
Um,
that's it.
levels of discipline. So it's not something you shouldn't just jump straight to dismissal. However, I don't know if the use of the word statutorily in the question is looking for an answer as to whether the law spells this out. To that, I would say no. What it is that the law gives grounds for termination, including something like misconduct, and then what amounts to misconduct could be many things. And then you investigate, and then you take it up from there. So that's my response.
Okay, thank you for that. And this question goes to Wing Commander. So Joanne writes, in a situation where you are dismissed without a fair hearing, for instance, if you were accused but no proper investigation was conducted, do you still report to the Labor Commission? Yes.
Yes, thank you for the question. I believe Kofi Kofi Adinkra touched on that. That
Yeah.
you have to go if it's wrongful in that the procedure was not followed. That is also a grounds for complaining to the National Labour Commission, because you are entitled to. There should be proper investigations conducted. It should not be a witch hunt. So if you are, not happy with the outcome, there's the right of appeal, and beyond that, you can go to the Labour Commission. But it's good to point it out to your employer, because the right of appeal is part of the disciplinary process. Once it's been determined that you have been found liable and the sanctions would apply and the disciplinary award is given, you can petition that. You have misgivings about the outcome, that no proper investigation was done. And sometimes the employer can set up a small committee to look into it, the issue, and then it's amicably resolved. But if you're still not happy, you can have recourse to the Labor Commission. Thank you.
Right. Thank you. Um, Lawyer Dinkra, to you again. Under termination, to what extent does the Labor Act protect employees from dismissal on discriminatory grounds? And so I think the question is in two phases. And then the person writes, secondly, under enforcement of employment contracts, how effective are the remedies? Example, reinstatement. I think this has already been touched on. So, Lawyer Dinkra, can you take the first part? The person wants to know to what extent does the Labor Act protect employees from dismissal on discriminatory grounds?
Yeah, so I mean, if you look at Section 62 of the Act, it talks about it gives us grounds for fair termination.
Mm,
However, the it doesn't mean that any ground not mentioned is unfair.
mm,
But at the same time, when we talk about unfair grounds for termination, it's there's a broad one. There's a broad one where the law says if the employer fails to show that the termination was fair, then it is unfair termination. There's that one.
okay.
But
Okay.
apart from that's a very broad one. But apart from that, we have a list of other protections such as discrimination. It's discrimination on grounds of race, ethnicity, religion, all those things. If you can't dismiss someone because they are pregnant, you are protected from not being terminated or victimized for joining a union or becoming a representative, an executive of a union or things like that. So to a very large extent, the and of course I've gone beyond what the person said. They said discriminatory grounds, right? So but I mean it's important to just to broaden it and let us see how it works. And so with regards to the specific question, it protects you to a very large extent because one, it mentions what amounts to discrimination. And mind you, it's not limited. It's not limited. And then two, where you feel you have been discriminated against, remedies are given to you to either, you can go to the Labor Commission. If resolving it with the employer does not work, you can go to the Labor Commission, and depending on the outcome, you may be entitled to reinstatement, re-employment, or you may be given what do you call it, financial compensation if
Compensation.
either reinstatement or re-employment is not a viable option. So that's to that extent, that is how we are uh, protected from discrimination.
All right. So, Eben, is reinstatement, re-employment, or compensation in monetary value? So I'll just take two last questions, then we take the closing remark from speakers. So this question is to Dr. Bassi, and Victoria writes, an organization has, as part of its conditions of service for staff, a required notice period before resignation or termination. Thus, management staff are required to give 3 months, senior staff 2 months, and junior staff 1 month notice or salary in lieu of notice. Does this contravene any provisions in the Labor Act?
No, I would say no. Once it's agreed between, there are different classes of employees, and for that matter, what the sensitive nature of the rules they play are. And so once this is agreed between the employer and the worker at the inception of the employment contract, I believe it is enforceable at law. The employer or this would not be contravening the labor act in any way. You mentioned 3 months, right?
Yes.
For 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 management staff.
So 3 months for management, 2 months for senior staff, and 1 month for junior staff.
No, no, no. That will not be discrimination. The discrimination may only come in if staff of equal or same class have different requirements. Even that we can argue for business necessity in terms of the nature of the work they do. But clearly, if it is on classifications, management staff will give X amount of time, senior staff will do, junior staff will do. It will not be against the spirit of the Labor Acts of Ghana.
Okay. All right. So Victoria, it means there is no contradiction over there. Now, the last question goes to Wing Commander Alute. And Messi writes, how long does it take for an employee's appointment to be confirmed? Also, in cases where you are working with a company for almost 2 years, specifically, and the appointment contract given to you states that your employment contract will be confirmed after 6 months. After 6 months, probationary period has been extended for the next 3 months. Ever since then, you have not heard anything from your employer as to whether your employment is confirmed or not. Would you advise the employee? I believe the question is, what would you advise the employee?
Yeah, I believe that the probationary period is for the employer and the employee to ascertain the goodness of it, whether you like the job, you can do the work. Whether so, if it is even extended, it has to be captured in the policies of the organization, the grounds under which an extension will be made. And in some policies, they give the default as the appointment being confirmed. If you don't hear from them after X number of months, it is deemed to have been confirmed. Because sometimes there is that laxity on the part of line managers to appraise, because you have to be appraised after your probationary period to ascertain that goodness of fit, whether we should continue the employment relationship or we should terminate. And the employee should not suffer the delay, because some line manager refuses to confirm. So it's always good to have that in the policy that if the time is up and the thing is not, you're not confirmed, then it is presumed that you'll be confirmed, because I'll give the benefit of the doubt to the employee and not to the employer. The employer has a duty. And it is also the employee's duty to draw attention to the fact that I've been here 6 months, according to the policy, have to be confirmed. It's not grounds for which they will terminate you, no. It's just to say that something is slipping through the cracks and you are bringing the attention to it, to rectify. I have
Uh,
encountered a couple of these situations before.
Wing Commander, so what if it's not stated in the policy? Does the Labor Act have anything that covers that? If after my 6 months probatory period or my 3 months probationary period, nothing is stated in the policy, no information is communicated to me, do I automatically become a staff, or the employer can still come at any time and tell me that I didn't confirm you, so you can go home?
Yes, that is why I'm saying that there must be a reason for not confirming. We know that to say that contracts must be reduced into writing, and if you work for a certain period, even in the contract capacity, you can be made permanent and all that. These are all terms and conditions of employment. So it is a requirement that you get the organization to determine the matter. Are you being confirmed? Are you not being confirmed? Rather than to leave it for 2 years as is in the question.
Okay. Okay. All right. Dr. Vasi, your mic was unmuted. Do you want to say something to that?
No, please.
All right. Thank you for that submission, Wing Commander Aluti. So, all too soon, I'd like us to draw a curtain on today's discussion. So, I'll take the closing remark from all our panelists, and then we will call it an evening. So, Lawyer Edinkra, let me take your closing remark.
Thank you. I think that this has been um, a very exciting session to discuss. I'm hoping that all our participants and those in their circles who benefit from them would would have gotten some valuable insights into how to manage their transitions. Um, and yes, and I keep saying that the more that we know, the more that we can do. And so I would wish everyone who has been part of this session the best and leave you with these words that I am stealing from Wing Commander. So if you plan to say them, you will not be able to say them now. Which is that you must plan ahead. You must plan ahead of your, of
Your
course, some
exit.
things come upon us. But aside those, as far as possible, we should plan ahead and manage our affairs accordingly. And that will help us, together with the knowledge we have learned, to always have smooth transitions. Thank you.
Plan ahead. This is very heavy, but some of us. Thank you for that. Wing Commander, I'll take your closing remark.
Okay, thank you very much, Silas. I share the views of Lawyer Dinkra that this has been very insightful. But I would want to add, to the fact that sometimes when we get our appointment letters and they tell us that we are subject to the terms and conditions of service of the organization, we don't even bother to ask for it. What are these terms and conditions of service? I think we
Yeah,
must be curious enough to know because that is the rule book. That is what you'll be judged on if things should start going, wrong. So I would say, yes, find out and take some time to read what you have signed up to. And of course, you'll be able to, that knowledge will put you in good standing to know how to defend your rights. Thank
Wing Commander, this thing.
you.
A friend of mine told me that she doesn't even know where her contract of employment is. All she knows is that this is the salary they are paying. So,
Well,
but thank you for that. Theodora said I missed her question. Wow. Okay, so Theodora was asking what happens if you are on probation for 6 months and it's extended for another 3 months. Is it actually legal? I think Theodora, we touched on that whilst answering another question. So kindly do well to play back the video. And I want all our audience to know that this video is going to be on our Facebook, it's going to be on our YouTube and our LinkedIn pages as well. So you can always refer and always have your notepad beside you so that you can take notes. Um, Dr. Bassi has dropped off the call. So I would want to say a big thank you to each and every one of you for joining us for this insightful session on the labor laws of Ghana, particularly as we spoke about termination and enforcement of employment. So a special appreciation also goes to our distinguished and amazing speakers, Lawyer Kofi Dinkra Jr. Thank you very much. Dr. Jeff Bassi in absence, and Wing Commander Aluti. We are grateful for you sharing your expertise and shedding light on such a very crucial and critical subject as this.
Thank
Now,
you very much for having us.
thank you too. Now, at the HR Certification Center, we are committed to equipping professionals and organizations with the knowledge and tools you need to grow in your business workspace. So, I want to say a big thank you to everyone who tuned in, everyone who asked the question, and all those who shared their contributions today. We've had a little over 200 people staying through this call with us. And we know it's been an hour and 30 minutes of your time, but this has been a great and insightful session for learning. So we would like you to know that legal training for HR and line managers is also upcoming from 25th October to 29th of November. And we are going to treat, this is just 1 hour, 30 minutes. We are going to treat the Labor Acts or the labor laws of Ghana for 6 consecutive weeks. So do well to reach out to us on 020-800-7585, and we'll be there to assist you. On behalf of the entire HR Certification Center team, I am Silas Apia, and it has been my privilege to moderate today's session. Until next time, let's all keep growing, let's keep learning, and have a wonderful evening. It's bye for now.
As HR leaders and functional line managers, decisions that we make daily can have legal implications. From recruitment to onboarding, discipline to termination, every step must be in alignment with the law. With this, we have put together legal training for HRs and line managers. This course is designed to give you the knowledge and clarity to lead lawfully. We will break down Ghana's Labor Act 651 in a simple, practical way. You will learn what the law actually says and what that means for your work. Do you know the probationary periods? Or how to properly document issues to prevent future legal risks? These are the things that are really important as a leader and to safeguard your organization. Whether you're a seasoned manager or a new business executive, this course is simply designed for you. To join our next cohort, call or WhatsApp 020-800-7585. It's your time to hop on the legal train.
Certification Center commits to a higher standard